Good evening, aspirants. Hope I'm audible and visible to everyone. So, in case I'm properly audible and visible too, please write in the comment section. Yes. So, anyone out there who can just write in the comment section if I'm visible and audible properly. Good evening, Priyanka. So, Priyanka, can you let me know if I'm audible and if I'm visible to you? Wait, we'll just start in 2 minutes. Great. So, okay, fine. I'm audible to everyone. So, we will be starting with the contract and SRA quiz today for MP Judiciary. Hope you all are preparing well. Right. So, I'll also just log in so that we can connect better with the comments and everything. So, before starting, you all know, I hope you all are preparing
Right.
well,
So I'll also just log in so that.
right? My screen is visible to everyone. All good, right? My screen visible to everyone. Is my screen visible to everyone? Priyanka, can you answer the first question? Yes, Priyanka. So, can you answer my first question? Quid pro quo means. What does quid pro quo mean? The options are given here. Something in return, adequacy of consideration, sufficiency of consideration, value of promise. So, Priyanka has given option 1. Right. Yes. Quid pro quo means something in return. Correct, Priyanka. So it is A. The option is A. Let us come to the second question. In a contract, consideration could be supplied by. In a contract, consideration could be supplied by only the promisor. This will be promisee. Okay. So is it only the promisee, even the promiser, only by parties to contract, or even strangers to contract? The option is D. Atidivya and Priyanka both say it is D. Yes. Now, can you all tell me, right, in which section of Contract Act we can find this? In which section will you find this in a contract consideration? Where do you find this, that it can be even given by strangers to contract? Yes, students. Section 2D. Very good. Very good. Yes. Yes. Section 2D. So I hope you all know what is Section 2D. Yes. Hope you all know what is Section 2D. Anyone who can just tell me what is Section 2D of Indian Contract Act? Let me know what is Section 2D of Indian Contract Act. Please tell me what is Section 2D. Consideration is defined. Very good, Shaktijar. Yes. Yes, Priyanka. The definition of consideration is given. And what is the definition of consideration? When Section 2, Clause D says, right, when at the desire of the promiser, the promisee, or any other person, right? This from here only we feel like, yes, so it can move from the promisee or any other person, and that is why even if someone is a stranger to the contract, it is he can supply consideration. Yes, Atidivya. Consideration which is given at the desire of a promiser, and at the desire of the promiser, the promisee, or any other person. Very good. Yes. Okay. Now, I'm sure that you all have heard about the leading case of Carlyle versus Carbolic Smokeball Company, right? So, who can tell me about this Carlyle versus Smokeball Company? Just see the question. The leading case of Carlyle versus Carbolic Smokeball Company is related to what offer? General, counter, invitation, or lapsed offer? Yes, students. The leading case of Carlyle versus Carbolic Smokeball Company is related to what offer? General, counter, invitation, or lapsed offer? Yes, it is the influenza case, correct. And what is the answer to this? Okay, Priyanka says C, Priyanka says A also. Any more answers to this? So, since it was given in a newspaper, the company actually gave an advertisement in the newspaper relating to the use of their smoke balls, what kind of offer does it, you know, do you think it is when we advertise something in the newspaper? So when you are advertising something in the newspaper, what is that advertisement general offer? Right. Let me see the yes. So this is general offer only, right? The answer is general offer A. Very good. Come to this question. The contract of life insurance. All know about life insurance. So what do you think is this contract of life insurance? Contract of indemnity, contract of agency, contract of guarantee, none of this. Can I see the answers? You all, it's it is good if you write the answer. Like I know you can write A and B, that is okay. But if you write the answer, that would be better um, for me also. Just write contract of indemnity or guarantee or agency. So, what kind of contract it is? Indemnity. Priyanka says it is indemnity, right? So, this is an answer which is indemnity, right? Just wait, students. What is indemnity and guarantee? Where is it defined? Write it. Can you tell me where is the definition of indemnity, guarantee, agency when we are just dealing with the question? Let us also yes the answers have already started coming. 124 and 126. Yes. So what is 124 and what is 126, students? What is 124? Indemnity, and 126 is guarantee. Very good. Very good, Shaktija. So yes, this answer for 4 is it is A, contract of indemnity. So life insurance is also a contract of indemnity. Okay. So I'll move to the next question. This is the next question. Every agreement to restrained marriage of any person other than minor is. Every agreement to restrained marriage of any person other than minor is. So what are the answers? Every agreement which is to restrain marriage of any person other than minor is what? Voidable, unlawful, void, or lawful. The first answer comes from Ati Divya Anand, void. Ankita, Niharika, and Shaktija also says void. Is me the exception to section 26. It's given in the question only. So along with this question, if I give you one more question, what is the exception to section 26? Then what is the answer? What is the answer? What is the answer, students? Yes, Atidivya, Niharika, Sai Darshan. I can see all of you here. Yes. Can you all give me the exception? Minor. Very good, Priyanka. Very good. The first answer comes for minor. N- No, Atidivya, which one is valid? Every agreement to restrain marriage of any person other than minor is void. Yeah, minor marriage. For minor marriage, the agreement is valid, right? Atidivya, right. For minor's marriage, if you are making an agreement in restraint of marriage, that is valid, that is not void, because it is an exception to section 26. Good, good, everyone. So I'll move to another question. Now, where no application is made and no time is specified for performance of promise, no application is also made and no time has also been specified for performance of promise, then the agreement could be performed within what time? 1 year, 2 year, 3 year, or reasonable time? Shaktija says reasonable time. What about others? Reasonable time. Priyanka also says reasonable time. And the answer is right, it's reasonable time. But can you tell me the section? Can you tell me the section? Can you also give me section? What is section 7, Shaktija? What is section 7? Atidivya says 46. What is section 46? Atidivya? Okay, so if I read section 7 and if I read section 46, okay, two answers are coming. Now, you all have given reasonable time, that is the correct answer. But which section will it relate to, that we need to understand. And for that, I'll be reading section 7 also for you all and section 46 also for you all. Others can also comment during this time when I'm reading the section. Now, section 7 says acceptance must be absolute. Absolute means it should be absolute and unqualified, right? So acceptance must be absolute under section 7 of Indian Contract Act. It is absolute and unqualified, right? So if you want to convert a proposal into a promise, if I want to convert a proposal into a promise, and the acceptance I need to give, that should be absolute and that should be unqualified, right? And it has to be, what is clause 2, where you people are actually getting a little confused. Clause 2 says of section 7, it can be expressed in some usual and reasonable manner, right? So it is talking about the manner in which acceptance has to be done, like that should be in usual and reasonable manner. Now that can also include time, that can also include place, that can also include the mode, okay? Any reasonable manner which the proposer has told. But here my question is, if no application is made and no time is specified, so we cannot relate it to section 7 when we are coming with this. We will go to Seedha, we will go to section 46, right? Time and place of performance. The specific section here is where by the contract a promiser is to perform his promise without application, and see in the question also no application is made and no time for performance is specified. So neither application is made nor time has been specified, both are missing. So this is, it has to be done, it has to be performed in a reasonable time, that is true, but that is under section 46. So for 6, the answer is we will relate to section 46. Okay. Right? That is section 46.
Every approach to restrain marriage of any person other than one person.
Now let us move to the next question. Indemnity. So like these are so, like, the level of the question here in the starting is easy. Some are easy, some are medium, some are hard level also. So can you tell me indemnity definition? You people have already told me, so I don't think I need to repeat this question, but since it is already given here, you people can tell me. 124. Yes. What does 124 say? If anyone can also write to me what is 124 of Indian Contract Act. What is section 124, student? Indemnity is defined, right? And what is indemnity? What is indemnity? What is indemnity?
Along with this question is a code that leads to one more question. What is the exception to section 26 that must be answered? What is the answer?
So one party promises to save the other from loss, is what Atidivya is saying.
Yes,
Right.
yeah,
So one party is promising that he will save the other from loss, which is caused by him, caused to him by the conduct of promiser himself or by the conduct of any other person. That is a contract of indemnity as under section 124. And the illustration says a contract to indemnify B against consequences of any proceeding which C may take against B in respect of a certain sum of 200 rupees. This is a contract of indemnity. So A is contracting to indemnify B against the consequences of any proceeding which C may take against B in respect of a certain sum of 200 rupees is a contract of indemnity. This is an illustration which is attached to section 124. Very good. Yes, yes, yes. Correct. The comments are correct.
now where no application is made
So we will move
and
to
no
the
time is
next question.
specified. So what is
Question number 8.
no application
In
is
case
made?
of acceptance by post, in case of acceptance by post, at what point the acceptance is completed as against the proposer? So you have read the question, right? In case of acceptance by post, at what point the acceptance is completed as against the proposer? Just see the option. Options are when the letter of acceptance has been put in course of transmission as to be out of the power of acceptor, when the letter of acceptance has been written. C is when the letter of acceptance has been received. D says when the letter of acceptance has been read by proposer. Answer time.
Standard option A, section 7. What is section 7? Khatija? What is section 7?
And we are talking about as against the proposer, right?
What is section 46?
So majority says A, only one person has said C. Yeah. Now, when there is a confusion regarding A and C, you will find that both look same. A says when the letter of acceptance has been put in course of transmission as to be out of the power of acceptor, and C says when the letter of acceptance has been received, but has been received by whom is not clear. It may be received by the by the proposer or by not the proposer, so that is not clear. So the correct answer for 8 is A. Right? It's A. And in which section do you find? Section 4. If you read section 4, what is section 4? Section 4 is very important. Like all this communication, acceptance, and revocation of proposals, which are in chapter 1 of Indian Contract Act, is really important. So I want to know what is section 4. It talks about communication when complete, right? So when is communication complete is given here, and if we see as against the proposer, it is complete when it is put in course of transmission to him so as to be out of the power of acceptor. Section 4 para 1. Very good, Atidivya. Right, correct. So everyone clear? The correct answer is A as given under section 4 of Indian Contract Act. ठीक है. I'll move to the next question. That is question number 9. So the question is where both parties are under mistake as to matter of fact, the agreement will be enforceable, will be voidable, not void, or void. Answer time.
Where by the contract a promise to perform some task must be made.
So what is the answer, students? Okay, whenever you are writing D, okay, fine, it's void as D says, it's void. And some Shaktija says voidable. Okay. Can you give me the section to which we can relate to with question number 9? Yes. Bilateral mistake, section 20, correct. And that relates to matter of fact only. Agreement void when both parties are under mistake as to matter of fact. The question says same thing. Both the parties are under mistake of fact. So the agreement here is void as said by section 20 of Indian Contract Act. So it is void. The contract here is, the agreement here is void. Right? We can move to the next question. Interesting question. A guru, A is a guru, okay? So A is a spiritual advisor. He is inducing the chela, his devotee, to gift him the whole of his property to secure benefit to his soul in the next world. So, what is the validity of this gift, student? Is it voidable, valid, immoral, or void? Answer time. So everyone says voidable. It's P, voidable. And why do you think it is voidable, student? Under which section can we say it's voidable? Yes, yes, very good, Shakti. Voidable at devotees option, correct. And why? Under which section? Under which section is it voidable? Under which section is it voidable? What is 19 and what is 16? What is 19, students, and what is section 16? 19A. Okay, okay, you all are relating uh good only. Yes. So all this section 16, 19A relates to what? What is this? Undue influence, right? So the agreement is voidable here at the option of the devotee. Correct. So we can move to the next question now. So finder of a lost thing, which is commonly the subject of sale, may sell it when lawful charges of the finder in respect of the thing find found amounts to what? One fourth. So when can the finder sell that thing which he has found? When the things amounts to one fourth of its value, half of its value, one third of its value, or two third of its value. So can you write the answer to this question? When will the finder of the thing, right? He can sell the thing. When will the finder, sell it? When it amounts to one fourth, half, one third, or two third of the value. Only Priyanka has written. Priyanka has given two answers. Priyanka, C and D. So which one should I take? The last one? Yes, yes, it is D only, two third of its value. Which section? Which section is related with section 11? The question 11? Yes, yes, Priyanka, correct. D, two third. As per which section? 169 clause 2. Very good, Shaktija, right. As per section 169 clause 2. Good. I'll move to the next question now. A hires a carriage of B. The carriage is unsafe, though B is not aware of it, and A is injured. Then what will be the consequence of it? B is not responsible to A for injury. B is responsible to A for injury. Both are contributory negligent, or no one is responsible for A's injury. A or B? Shaktija says A or B, right? Not responsible. What do you think? What do you think will be the answer to this, and which section will it relate to, students? Will B be responsible or will B be not? Ota, Shaktija has written answer A. B is not responsible. Okay. So what do the other students think on this question? What should be the correct answer to this? So A is hiring a carriage. The carriage is unsafe. Though B is not aware and A gets injured. But A has hired it. Okay, also remember this, that A hired the carriage. So what do you think? Will he be responsible or will he not be responsible? Okay, let me read the comments now. Not responsible, not responsible, will be responsible. Oh, Priyanka then says will be responsible. Sanskriti says will be responsible, and Priyanka also says will be responsible. So, why do you think will be responsible? Which section talks about the responsibility? Why do you think he will be responsible? Why do you think will he be responsible? Why do you think they will be responsible? Section 150. Yes, this was what I was looking for. Thank you, Priyanka. Section 150. What does 150 say? The bailer has a duty. 150 says that the bailer has a duty to disclose the faults in goods bailed. The bailer has a duty to disclose fault in goods bailed. And if such goods, in that section only, you will see the last para. If such goods are bailed for hire, the bailer is responsible for such damage, whether he was or was not aware of the existence of such fault in the good bail. And if you see the illustration, this is the same illustration as given in the question. So it is according to section 150, B is responsible to A for injury. So the correct option is option B. B is responsible to A for injury. Right? Right, students? So I'll move to the next question now. I'll move to the next question now. Okay. So A promises to paint a picture, right? For B up to December 31 and accepts an advance of rupees 1000. After making of the contract, A's hands are chopped off in an accident on December 25. B is entitled to refund of rupees 1000 from A under which of the following section? 73, 64, 65, or 75? Tell me. So though A has taken the advance money, but now since his or her hands are chopped off, okay, in some accident, will can the client take the money back? Yes. Under section 65. Very good, Priyanka. Yes. Sanskriti also has given the answer. Yes, 65. Let me move to Aditya. Yes, Adivitya also. Right, Adivitya. 14. Now, this is a section which you can all answer, I guess. It's easy also. Specific performance of a contract cannot be enforced in favor of a person who has obtained substituted performance of contract under section 20. Statement is correct, incorrect, can be performed according to distribution of the court, or none of these. What do you think? Sanskriti has said correct. Okay. So, specific performance of a contract cannot be enforced in favor of a person who has obtained a substituted performance of contract. What will be the answer? Yes. Any answer? Correct. All says a statement is correct. Shaktija says, okay, A statement is correct. Under which section? Student, what is section 20 of SRA? It talks about 20, but what is 20? Substituted performance. Good, good. So I'll move to the next question now. Section 30 lays down that the court, on adjudging the rescission of a contract, may require the party to whom such relief is granted to restore, so far as may be, any benefit which may have received from the other party, to make any compensation to him which justice may require, both A and B, or none of this. What do you think? Sanskriti has given the first answer. Both are correct, as she says. Okay, others also think the same. Yes, students, yes, correct. Both are correct. The answer is both are correct. So we will move on to the next question now. Promises which form consideration or part of consideration for each other are called, see the option, reciprocal promises, cross offer, conditional promises. Yes. What is the answer to question 17? Promises which form the consideration on or part of the consideration for each other are called, Priyanka says, reciprocal promises. Reciprocal promises under section 2F. Very good. Yes, yes, correct answer. What is reciprocal promise, student, under section 2 clause F of Indian Contract Act? If you read the section, you will find that promises which form the consideration or part of consideration for each other are called reciprocal promises. So this is the answer is reciprocal promises as defined under section 2 clause F of the Indian Contract Act. Good. Next question, tender. Now, what is tender? Is it an offer? Is it an invitation to an offer? Is it a counter offer or none of the above? Please write the answer. Write either offer or invitation to offer. What is tender? Is it offer or is it invitation to offer? I can see the answers coming up as invitation to offer, right? Right. So the correct answer is invitation to offer. Tender is an invitation to offer because you are bidding something, right? You are actually, inviting to bid for a project. Come to question number 19. Past consideration is valid in where? Is it valid in England only? Is it valid in India only? Valid both in England and India, or neither in India nor in England? What is the correct answer? Is past consideration valid in England or not valid? And in India, is it valid or not valid? England only. Okay. What other answers are there? C, both. Okay. Where else? सी इंडिया के बारे में तो डाउट होना ही नहीं चाहिए क्योंकि इंडिया में तो वैलिड है पास्ट कंसिडरेशन इज वैलिड इन इंडिया व्हाई बिकॉज व्हेन यू सी द डेफिनेशन ओनली in section 2 clause d it talks about past present future all considerations are included in Indian Contract Act, right? So India के बारे में we have no doubt India में valid है, but is it valid in English law also? What do you think? Is it valid in English law also? It's only valid in India, right? It's not valid in England. Why? Because in English law it is not recognized. Past consideration is not a consideration according to English law. It is a consideration according to Indian law, right? Section 2D talks about past, present, and future consideration, all three. So the answer is only India, right? India only. Come to next question. An agreement not to pursue any legal remedy to enforce right under section 28 is valid, voidable, void, or unenforceable. Under section 28, What is section 28, students? What is section 28? So the answer which is coming is void from everyone. Atidivya, Sanskriti, Priyanka, Shaktija, everyone has said void. Right. Uh, so can anyone tell me what is section 28? What does it relate to? Yeah, very good, Sanskriti. Restraint to legal proceeding. Correct. So section 28 talks about restraint to legal proceeding. Correct. It's void. Okay, the answer is void. Okay. Agreement by way of wager under section 30 is void, voidable, valid, or unenforceable. Void. Very good. It's void. Okay. So wagering agreement is void. Contingent contracts are valid. Okay. Contingent contract is valid, but wagering agreement is void. Come to next question. Agreement in connection with horse racing. Any agreement in connection with horse racing, what do you think? It is valid or void, voidable or unlawful? Agreement in connection with horse racing is Atidivya says valid. What about others? Horse racing is valid or not valid? Valid. Very good. Which section? 30 says that it is valid. Great. So the answer is valid, okay? The answer is valid. Let us move to the next question. Who is a Bailey? Bailey is a person who delivers the good, to whom goods are delivered, through whom goods are delivered, or who carries the good. Who is a Bailey? Yes, good. Atidivya, good. Horse racing is a game of skill. Good. Lakshman case. Good. Who is Bailey, students? And where is it defined? In which section? Write the section also. So Bailey is a person, yes, under 148, to whom goods are delivered. To whom goods are delivered, and the section is 148. Section 148 defines bailment, defines bailer, and defines bailey. All three are defined in the same section 148. Bailer, bailey, bailment. Everything defined under section 148. So the correct answer is to whom goods are delivered. Okay, we can move on to the next question now. Okay, now this is a question which you need to answer. Akash promises Bashir to give 10 box of chocolates for 500 rupees. Such a promise between Akash and Bashir is what? It's a reciprocal promise, it's a contract, agreement, or none. What do you think? Now come to question number 24 and answer it. It just got lost. Yes. So tell me the answer to 24, students. Atidivya says agreement, Priyanka says contract. So when Akash is promising Bashi to give 10 boxes of chocolate for 500 rupees, such a promise is a, and the correct answer is, what is the correct answer? What is the correct answer, students? Okay, write the question number, students, and post your answers. 25 A or B or C or D, whatever you want to post, but please write the question number also along with it. Either write the answer, full answer, or write 25A, 25B. In which of the following cases related to general offer it was held that there is no requirement to communicate acceptance if not required by the proposer? So Atidivya says A and C. Okay, right. The answer, correct answer is A. Students, the correct answer is A. C. The case of Carlyle versus Carbolic Smokeball Company. In this, it was, it laid the foundation for unilateral contract, which is often cited by the courts of England and Wales, holding that unilateral contract are an exception with regard to notification. Okay. Uh, so there is some typing error here, but the case provided a remedy in contractual disputes and also in other statutes like consumer protection. And so this was the case in which it was said that there is no requirement, if there is no requirement to communicate acceptance, then it will not be required. because in this case when the lady consumed the smoke ball, she it was a general offer, and consuming in the smoke ball itself is an implied acceptance. You don't have to do that expressly. If they would have written in their newspaper that whoever is using our carbolic smoke ball company and wish for the compensation if they if they get infected with influenza, will have to communicate first. You need to communicate your acceptance and then start using, then it is okay. But in that general offer, no such mode was specified, so there is no need to communicate acceptance also in such cases. So the answer is Carlyle versus Carbolic Smoke Ball Company. Come to 26. Doctrine of unjust enrichment was propounded in which of the following cases? In which of the following cases was the doctrine of unjust enrichment propounded? Yes, Atidivya, in both cases, in Lalman, in that Lalman Shukla code did not tell about that. Okay, in that too, we need to communicate, right? In that, it was the communication was needed. Because when you there it was needed, because the court to dismissed the appeal saying that there must be knowledge and consent to offer from both the side. So there the acceptance had to be communicated, but in Carlyle versus Carbolic Ball Company it was not needed. Okay, next question. You people have started answering. Mosses versus Macfarlane is your answer. Yes, and the answer is Mosses versus Macfarlane. In this only the doctrine of unjust enrichment was propounded, right? And it was propounded by Lord Mansfield, right? So the correct answer is Mosses versus Macfarlane. Come to 27. Which of the following sections deal with devolution of joint rights? Devolution of joint rights is dealt with under which section? Devolution of joint rights is defined under which section? Answers have started coming. Yes. So I'm giving more 5 seconds to all to answer. 42, 45, 45, 45. And the correct answer is section 45. Right? The correct answer is section 45, because as per section 45 of Indian Contract Act, when a person has made a promise to two or more persons jointly, then, unless a contrary intention appears from the contract, the right to claim performance rests as between him and them, with them during their joint lives, and after the death of any of them, with the representative of such deceased person jointly with the survivor or survivors, and after the death of the last survivor, with the representative of all joint promisors. Right? So, the answer is section 45. Come to next question. Now, this is again one important question. There is a contract between Juhi, who is a dancer, and Janvi, who is the manager of a theatre, to dance at her theatre for 5 nights in every week for next 4 months. And Janvi engages to pay her 500 rupees for each night's performance. On the sixth night, Juhi willfully absents herself from the theatre, and Janvi, in consequence, resigns the contract. So the options are: Janvi is not entitled to claim compensation, Janvi is entitled to claim compensation, as contract is rescinded, no compensation is to be paid, or none of the above. Now this is one of the important questions. Giving you all 5 seconds to answer. Also mention the section, students. So the answers are B, B, Aditya says C, right? So will Janvi be entitled to compensation or will she not be entitled to compensation? Which section do you feel is relating to this question? Which section? 39. Very good. Very good. Now 39 is also, we also say that 39 is the section which covers the topic of anticipatory breach of contract, right? Anticipatory breach of contract. You have to read section 39 with section 75 also, right? So the answer to this question is, as per section 75, a person who rightfully resigns a contract is entitled to compensation for any damage which he or she has sustained through non fulfillment of contract. Therefore, Janvi is entitled to claim compensation. So, whenever you are reading section 39, always read it with section 75. Okay? Section 39 needs to be read with section 75 of Indian Contract Act. Clear this one? Yes, the illustration of 75 is same as that of this given problem. There only it is singing, here it is dancing, but it is same. So, Janvi will be entitled to claim compensation as per section 75. So, whenever you read 39, read it with section 75, anticipatory breach of contract. Okay, come to next question. A authorizes B to buy 100 bales of cotton on account of A and to pay for it out of A's money remaining in B's hand. B buys 1,000 bales of cotton in his own name so as to make himself personally liable for the price. Right? So, what is the correct answer? A can't revoke B's authority so regard as payment for cotton. A can revoke B's authority so far as regards payment for the cotton. A can revoke B's authority so not far as regards payment for cotton, or none of the above. Again, an important question. Please write your answers. What will be the answer? Only one answer has come yet. Others also please answer. Just see the question and answer. Which section? Which section? Mention the section also with your answer. So you must have heard about revocation, right? 202. Okay. So is it 202 or 204? Let us see the question. A authorizes B to buy 1,000 bales of cotton on account of A and to pay for it out of A's money remaining in B's hand. ठीक है? B buys 1,000 bales of cotton in his own name so as to make himself personally liable for the price. So here A cannot revoke B's authority so far as regards payment for cotton under section 204. If you all see section 204, you will see the same illustration, right? Same illustration in illustration A, right? So there are two illustrations given in section 204. One is where he is making himself personally liable, and the second one which says not personally liable. So your question here is relating to illustration A of section 204. So A cannot revoke B's authority so far as regard payment for the cotton. Correct? Come to next question. According to section 72, a person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it, right? So this is already actually given 72. So I think I needed the section. So, okay, so according to which section actually it should be. So the answer is already given here. So I don't think I'll proceed with this question. You'll already know that it is according to section 72, right? Come to next question. Performance of contract under section 20 clause 1 shall be undertaken unless the party who suffers such breach has given a notice in writing of not less than dash days to the party in breach, calling upon him to perform the contract within such times as specified in the notice. So, what is the time period here? 60 days, 45 days, 30 days, or 15 days? Okay, one answer has already come. What about others? If you see 20 clause 1 of SRA, what is the day? How many days mentioned there? Only one answer has come till now. What about others? The answer is okay. So the moment I appear, answer session will be finished. Yes, Aditya, the correct answer is 30 days. Right. Come to 32. Under Section 37 of SRA 1963, a temporary injunction can be granted after settlement of issues, before conclusion of plaintiff's evidence, before conclusion of defendant's evidence, or at any stage of the suit. Under Section 37 of SRA. Atidivya says any stage. What about others? Giving you all 5 seconds. Any stage. Very good. Under section 37, the answer is any stage of the suit. So the temporary injunction can be granted under section 37 at any stage of the suit. The answer is at any stage of the suit. Come to next question. Which new remedy is inserted by SRA Amendment Act of 2018? Injunction, substituted performance, recovery of specific immovable property, none of this. Answer time starts. Which new remedy is inserted by SRA Amendment Act of 2018? 5 seconds to everyone to answer. अच्छा, ये हो सकता है ना कि मैंने जो क्वेश्चन अभी आपको बोला, आपको शायद थोड़ा लेट वो आपके फ़ोन पर या लैपटॉप पर वो आए। इट माइट हैपन बिकॉज़ व्हाटएवर दिस इज़ अ लाइव सेशन, सो जो मैं अभी बोल रही हूँ, मे बी इट माइट अपीयर टू यू आफ्टर अ मिनट और समथिंग। सो ऑलवेज़ राइट योर आंसर्स विद द क्वेश्चन नंबर, ओके? सो दैट आई कैन अंडरस्टैंड कि अच्छा आपने अभी उस क्वेश्चन को ही सुना है। तो अभी हम क्वेश्चन नंबर 33 पर हैं, and only Atidivya has answered substituted performance, which is correct answer, right? The new remedy inserted by SRA Amendment Act of 2018 is substituted performance. So substituted performance is the correct answer. Very good, Atidivya. Let's move on to the next question. Which section of Specific Relief Act deals with special court? Section 20A, 20B, 20C, or 20? So your time starts now. स्पेशल कोर्ट्स कहाँ डिफाइंड है स्पेसिफिक रिलीफ एक्ट में? स्टूडेंट्स देख लो आप, सेक्शन 20 में है। 20 तो सबको पता है, सब्सटीट्यूटेड परफॉर्मेंस है, हमने इतनी बार उसकी बात करी है सब्सटीट्यूटेड परफॉर्मेंस की। सो 20 ए, 20 बी, 20 सी से अब आप चूज कर लो। Shaktija says 20B, Atidivya says 20B. The correct answer is 20B, right? The correct answer is also 20B. Very good, Shaktija and Atidivya. ठीक है, सेक्शन 20B टॉक्स अबाउट स्पेशल कोड्स। कम टू नेक्स्ट क्वेश्चन। विच सेक्शन ऑफ स्पेसिफिक रिलीफ एक्ट डील्स विद ये तो हमने कर लिया। कम टू क्वेश्चन नंबर 36। The cost of any proceeding under section 28 shall be in discretion of whom? Cost of any proceeding under section 28 is in the discretion of whom? State government, central government, court, none of the above. Time starts. सेक्शन 28 के अंदर किसके पास कॉस्ट ऑफ प्रोसीडिंग इज इन द डिस्क्रिप्शन ऑफ whom? So the answer has come up. Two people have answered court, and the correct answer is also court. Yes, the correct answer is court. Okay, court under section 28. If you see, it is in the discretion of the court. Section 28 में, ठीक है? Come to next question. What is the meaning of the principle of quia timit in the context of law of injunction? Quia timit. So the options are some future probable injury to the right and interest of person, some past injury to the right and interest of person, some injury capable of being compensated in money, none of the above. आप बताओ. So what is the correct answer, students? Quia timit. If you have heard this principle, quia timit, please write your answers for this. Quia timit, if you have heard. What is the meaning? Some future probable injury to the right and interest of person, some past injury to the right and interest, some injury incapable of being compensated, none of the above. The answers are A. That is, some future probable injury to right and interest of person is being said by everyone, and the answer is yes. The principle of qua timate in context of law of injunction means some future probable injury to the right and interest of person. So the answer is A. Okay. Let's move on to the next question. Section 36 of SRA classifies injunction into how many categories? Okay, section 36. Two categories, three categories, no categorization, or none of the above. Section 36 classifies injunction into how many categories? Answers, time starts now. Shaktija says two categories. What about others? Temporary and perpetual, two categories. Very good. Very good. Yes. So the answer is two categories, and both are temporary or perpetual. Very good. Let's move on to the next question. Declaratory decrees are discussed under which section? From 31 to 33, from 26 to 30, from 38 to 42, from 34 to 35. Declaratory decrees are discussed under which section, student? Declaratory decrees are discussed under which section? From section 31 to 33, from section 26 to 30, from section 38 to 42, from section 34 to 35. Okay. So the answers which have come is for you people are proposing D, option D, 34 to 35, right? And the correct answer is 34 and 35 only. Yes, the correct answer is D. If you see chapter 6, it talks about declaratory decrees. Okay. If you see chapter 6, which is 34 and 35, talks about declaratory decrees. Chapter 6. Okay. Chapter 6. Remember this for declaratory decrees. Let us come to the next question. Specific relief is the remedy which aims at. Specific relief is the remedy which aims at what? Exact fulfillment of an obligation, specific performance of contract, either of them, none of them. Specific relief is the remedy which aims at exact fulfillment of an obligation, specific performance of contract, either of them, none of them. Answer time starts. So either of them. You all are proposing the answer either of them. So specific relief aims at both. Yes, it aims at exact fulfillment of obligation also, and specific performance of contract also. Yes, so it is aiming at both A and B, either of them or both of them. Since either of them is given here, we will choose the answer either of them, right? So this brings us an end to the questions here. But one last question from my side is, I'll just be telling this question to you all so that you can answer. I want to know the section of continuing guarantee. Continuing guarantee under Indian Contract Act. What is the section of continuing guarantee under Indian Contract Act? 129. Very good. Very good. So this brings an end to our session, right? One more question if I ask you all, right? One more question which I think I'll ask more four questions. Last kit char or question I'll be asking you all. So my first question is the definition of trust under Specific Relief Act is given under which section? Definition of trust. Definition of trust, students. Where is the definition of trust given under Specific Relief Act? 2C. Very good. 2C, very good. More three questions to be asked. Now, my question is relating to a problem. ठीक है? A instructs B, a merchant, to buy a ship for him. A is instructing B, a merchant, to buy a ship for him. B employs a ship surveyor of good reputation to choose a ship for A. The surveyor makes the choice negligently and the ship turns out to be unseaworthy and is lost. Then who is responsible here? So A is instructing B to buy a ship for him. B has employed a ship surveyor of good reputation to choose a ship for A, but the surveyor has made a choice negligently and the ship gets lost because it was not seaworthy. So who is responsible here? Is B responsible or is the surveyor responsible to A? Who is responsible here to A? Will be the merchant responsible or will the ship surveyor responsible to A? Surveyor, very good. Which section? Which section of Indian Contract Act? Which section of Indian Contract Act? Yeah, surveyor is responsible. Which section? Which section? Yeah, B is responsible. Yes, ship surveyor is responsible. B is not responsible. B will not be responsible. The ship surveyor will be responsible. Because why is B not responsible? I'm telling you. Because if you see section 195, which Ati Divya has mentioned, yes, section 195, then B has acted properly because he has employed a surveyor who has a good reputation. But the surveyor has acted negligently under section 195. He is responsible for his act. Okay, so the surveyor will only be responsible. My second last question for today is the definition of sub-agent. At which section defines sub-agent? Which section defines sub-agent? So before I can turn on my camera, I need all the answers. Yes. Please, if anyone else is left to give the answer, please give your answer. 191 is the correct answer. Right. Right. Now, my last question for today. My last question for today. A's son, it's a problem, okay? A's son has forged B's name to a promissory note. A's son has forged B's name to a promissory note. B, under threat of prosecuting A's son, obtains a bond from A for the amount of the forged note. If B sues on this bond, then what is going to happen? Will it be void? Will it be voidable? Will it be valid, or the court can set this bond aside? So, if you all want me to repeat the question, I can repeat it. A's son has forged B's name to a promissory note. B, under threat of prosecuting A's son, has obtained a bond from A for the amount of the forged note. If B sues on this bond, then what is going to happen? Will this bond be valid, voidable, valid, voidable, void, or the court will set it aside? And please mention the section. Yes, students, please start answering. Your time starts. A's son has forged B's name to a promissory note. B, under threat of prosecuting A's son, obtains a bond from A for the amount of the forged note. What is the validity of this bond? If B is suing on this bond, what will happen? Will it be held valid, void, voidable, or can the court set it aside? Very good. Yes, yes. The court may set it aside also under section 19A. Though it is also related with section 16, yes, undue influence, but the court may set aside the bond under section 19A. The court can, if it is coming in a MCQ, it will be the court may set aside, right? The court may set aside the bond under section 19A. So this was it. This was my last question for today, right? All the best, students. So whatever we have done today, I hope that you all can just revise at home all these sections. We have just done some important portions which I felt was important, right? So I and also from the previous years. So now it's time that you all start revising all the questions which we discussed today, and all the case laws also, all the important case laws also. Contract act and SRA both are very small act and very easy also. So I think you all can do this act very properly. There is no such hustle and tension about this. So I hope that you all will be doing best and giving your best to this. So all the best. Now I would like you all to comment how was the session. So you all can just comment about the session today so that we can improve later also. Yes, students, please you all can comment now on the session. Students, are you all there? You all can comment on the session and you can start leaving. Thank you, Karan. So those who have done posting their comments can leave. Thank you so much for attending the session and thank you for being so patient. All the best, students. Others can also post and comment and just leave the session. Thank you, Shaktija. Thank you, Karan. If you all want to give some suggestion, you all can give that also. That will be helpful for me. Okay. Thank you so much. I'm ending the streaming now.